1 is now in session.
Thank you. You may be seated. We're here in the matter of State of Arizona versus 6635 North 19th Avenue, Inc. It's our case number CACV150550. These proceedings are being audio and video recorded. We do ask that you identify yourself and your client the first time you approach the podium. Each side will have 20 minutes. Appellant, you'll be responsible for reserving whatever time you'd like for rebuttal. We've conferenced this matter. We have reviewed the record and have discussed it extensively. And with that, you may proceed.
Thank you, Your Honor. Good morning, judges. First, I'd like to, if I could, I'd like to reserve 5 minutes. So if I could be cut off at the 5-minute point, Your Honor, I'd appreciate it. The analysis that I presented, it's basically, there's 5 issues for the judges this morning. And they basically go in a certain order of priority. I tried to list them in the priority on page on the statement of issues page of my reply. And the first issue was whether the civil investigative demand, which is a pre-suit discovery device by the Attorney General, whether in this particular case the investigative demand was supported by the Consumer Fraud Act. As the panel is well aware, the Attorney General, and I'm not disputing this proposition, the Attorney General is well within its rights to engage in pre-suit investigative demands. That's not at issue here this morning. The important issue that we have here this morning, as I see it, is whether on the facts of this case there was a sufficient reason to believe on the part of the Attorney General's office to believe that there was a violation of the Consumer Fraud Act at this Woodbridge apartment complex.
At least it's argued in the answering brief in the record that the AG looked at what the city was doing. There was a complaint and other information, and they decided to ask the questions, get the information to determine whether it then wants to proceed with a consumer fraud action. So going back to, as I think I recall, 2012, they started looking at information and they said, we'd like information for these 3 years. And it seems that the legislature in the statute has given them that authority. Well,
Your Honor, if you were to look at it in a vacuum, you might find that would be a reasonable thing for the AG. But in this particular case, it's not a situation where the AG was receiving complaints regarding fraud complaints at the apartment complex.
Why do they have to receive complaints? Why can't they use the authority given to them by the legislature to investigate when information comes to their attention, whether in news reports or, reviewing advertisements or otherwise?
Well, the reason is because the law does not permit it, Your Honor, with all due respect. In that case, the key case is United States versus Powell. It's a Supreme Court case, 379 U.S. 48, 1964, Justice Harlan on the U.S. Supreme Court. And the pertinent provision in the Supreme Court case is the following. Because the Supreme Court looked at that, and it stated very clearly in this case, the U.S. versus Powell case, that there has to be a standard before the government can go on a search into private property records. Number one, there has to be a standard. And in the U.S. versus Powell case, the U.S. Supreme Court said that the investigation conducted by the government has to be for a legitimate purpose, that the inquiry has to be relevant to that purpose, that the information sought is not already within the government's possession, number 3, and that they followed the administrative steps, and that the government has determined in good faith that an examination of the objects or papers is necessary. Now, those are 5 standards according to the U.S. versus Powell case, and they didn't meet those 5 standards because, especially standard number 3, which the information that they sought, which were the prior cases in 2012 that you mentioned, the city action against the apartment complex for the AC violations, they already had that information. And they didn't meet a second part of the test, which is that they have to seek this information and have reasonable cause to believe it has to be related to the Consumer Fraud Act. In other words, they have to have reason to believe that a fraud is being committed, not a breach of contract because some AC units went out.
Why can't they reach that conclusion based on the fact that there's advertising on the internet? Do they, I guess going back to Judge Portley's question, does there have to be a specific complaint from a consumer that they saw an advertisement and relied on it, or can they not do their own research and determine that there's an advertisement that may violate the...
Well, this is somewhat related to Judge Portley's question, as you indicated, Your Honor. Just seeing some information on the internet, that leads to the next point. If they see information on the internet and they're predisposed against this private property owner because of some prior unrelated cases that are a breach of contract in the nature of breach of contract for AC units going down, no fraud, no evidence of fraud, and then they look on the internet, and what they did is they pulled the 2 prior cases, not dealing with fraud, dealing with AC and breach of contract. They go on the internet and they see that this apartment complex is marketing the property, and the marketing is all in the nature of puffing. They had no reason to believe that any marketing of these units was deceptive or fraudulent. So all they had to go by, and this is the violation of the U.S. versus Powell case, the Supreme Court case, because the Powell case said, and the Herndon case, the Babbitt versus Herndon, that was cited by both sides. We're both relying on the Babbitt versus Herndon case, and I would go to that next, Your Honor. So the answer to your question is no, that's not enough, because then they go to the internet and they see puffing and advertising for tenants, which most apartment complexes do, and they had no reason to believe that those advertisements were deceptive or fraudulent. No complaints, which goes to the second part of your question, and that's why I think you have to have some complaints regarding fraud or deception, or there's no standard. Otherwise, the government can do whatever it's want and then go in with a pre-investigative demand and issue a subpoena, and that leads to the third point, the overbreadth of the subpoena. It would issue the subpoena without a standard, reasonable cause to believe. There has to be a standard, and that's the U.S. versus Powell. Number 1, they already had the information. Number 2, they go to the internet. There's no evidence of fraud. Number 3, no complaints regarding fraud.
No evidence of fraud. If they're suggesting, if their concern is that these problems are not isolated, that it may be pervasive, the entire complex, and if they look at the internet, what are you suggesting would have been required for them to satisfy the standard?
If a couple of tenants had come in and filed a complaint that they were misled or deceived by the advertising, in other words, that the apartment complex was advertising a condition in the unit that when they got in there that was concealed, that was not open and obvious, that they could not have ascertained by
so
review of the unit.
As long as there are a couple of people who file a complaint, then there's not an issue?
in my estimation, if there were a couple of people filing complaints that there was advertising on the internet, to address your internet question, that there's advertising about a condition of the property that turned out that was not open and obvious and could not have been ascertained as caveat emptor, as a buyer beware, through an investigation, a reasonable investigation, and was concealed in some way. If you get into that situation and it turns out that there's a couple of complaints that we've got some deceptive advertising because they're advertising X in the units and it's Y in the units, and we could not have discovered that through an inspection, then they can come in and say, you guys are running some kind of scam here on the internet. But
I guess I'm just puzzled why you necessarily need the complaints. You may have people whose complaints overstate things. On the other hand, you may have people who maybe the Attorney General looks and thinks these are people who have difficulty, have language barriers. They may not even understand how to file a complaint. But if the underlying issue is there, it's our job to look and make the determination, or at least to investigate.
Well, Your Honor, that sounds good, except that as a court of law, as a matter of law, there has to be a standard to protect the constitutional rights of the private party, the apartment complex. There has to be a standard. The standard isn't that the Attorney General just gets a feeling, or they review a couple of prior unrelated cases that have negative publicity in the local news, and then they decide they're going to be through political motivation, go in and, based on their supposition down the street in the AG's office by looking at the internet, why don't we go in and issue a subpoena when we don't have any complaints of fraud, we have no objective evidence of any deception or fraud, as opposed to an AC contract problem, and we want to get all their papers. That leads to the next point. So then they issue the subpoena, which puts your question in context. So they get a feeling by looking on the internet, they've had these two unrelated prior problems. We looked on the internet, we think they might be committing a fraud, but they don't have any objective evidence, no complaints. So then they issue the CID, and the subpoena that they issued is overbroad because then they went in and asked for tax returns, the ownership documents of affiliated companies, the parent company, and then they asked for all the books and records, all the repair invoices for the last 3 years at the property, all the leases for the last 3 years at the property. If you look at the subpoena, the CID in this case, the breadth of that subpoena is extremely broad.
Overbreadth is a different issue than whether it's appropriate to go in the first place.
But it's not completely different because it puts your prior question into context. In other words, if the AG's office is legitimately looking at the internet and they have a legitimate concern about fraud or deception, and they had no complaints about that, they're just going off prior unrelated cases, and then they decide to do their investigation. If they had a legitimate concern about deception, which is not occurring, then they would fashion a subpoena that would be narrowly targeted to that concern, but an overbroad subpoena suggests, the inference would be, that they're not constrained by their supposition. It's overly broad, they're on a fishing expedition, and the court should draw a strong inference if the government's doing this and impinging on the constitutional private property rights of that landowner and asking for everything but the kitchen sink on a supposition, that would draw into question their motivation and whether it's genuine or not based on this internet, on the internet matter. They were asking, and it raises not only the political consideration that the Herndon case said to be concerned about, but looking back at it in hindsight, I looked at it in hindsight and I thought, those two prior cases led to civil fines and a lot of money that the private property owner was faced with. And how do we not know, and why would the court not ask the same question of AG counsel? I hope you do. How do we know that civil investigative demand wasn't in the nature of a post-judgment discovery in order for collection purposes, which would not be permitted because that's outside the Consumer Fraud Act. So we don't know their motivation. That's the problem.
But isn't there more investigation beyond just what was resolved over the AC issues? If the investigator, Agent Opp, I've forgotten the name.
Melissa.
Finds other concerns, other problems. Why doesn't that lend credence to what the Attorney General.
Because when we had that evidentiary hearing, Your Honor, when she was on the stand during that evidentiary hearing before Judge Bustamante, I had her on the stand and I asked her questions like, were you qualified to go in there? Are you a certified inspector? She said no. When you went into the units, which units did you go into? She could not identify them. When she said certain units were down and they weren't operating, like toilets or facilities weren't operable in some of the units, I said, were they occupied? She didn't know. The apartment complex was a work in progress. There were about 50 to 75 units that were down because there were contractors going in and working. I asked her to identify the units she went into and whether they were down at the time, or whether if there were toilets and facilities that went down on a few tenants there, did she investigate whether they caused the problem or the landlord? Because if a facility goes down, you don't know who's causing that. And every time I asked her a question, I got a non-answer or blank. She couldn't answer any of my questions. And that leads to the next issue. Then the AG's office submitted a proposed form of findings of fact and conclusions of law, and they listed about 20 findings of fact and 10 or 12 conclusions of law. And I cited the case to the court, and Judge Bustamante just rubber stamped it. So it's not her order.
Did you object? Did you
I
file
didn't.
an objection to the findings of fact and conclusions of law?
100%. I did it more than once. Yes, I did. I did object to it. And the Industrial Building Materials, Inc. versus Interchemical Corporation, 437 F. 2nd, 1336. That's a Ninth Circuit case. It's federal law, and as I understand it, Arizona follows the federal courts in terms of procedure, not substantive law, but on procedure. In this case, on procedure, it takes its guidance.
No, we don't.
Well, it's guided by federal procedure, the state of Arizona.
There are judges routinely who sign findings of fact and conclusions of law that are presented, and they become adoptive as if they were their own. That's not just rubber stamping, because we've given credence to it in termination of parental right cases.
This case, this is the Atlantic, this
I
industrial
understand.
building.
Oh, I understand.
Said that this is a-
Arizona's never said you can't do that.
Well, but this is a practice that the Ninth Circuit, which covers Arizona, the Ninth Circuit's made it clear that that is a practice that is discouraged and frowned upon, because then the appellate court, and you should welcome,
Court.
and Your Honor, with all due respect,
I'd like to be a federal court, but we're
right,
not.
but you should welcome that discouragement by the Ninth Circuit, because the rationale behind that discouragement of having the advocate submit the findings of fact and conclusions of law is that you have a judge signing it, and this Court of Appeals, for example, doesn't have the benefit of Judge Bustamante's independent, nuanced evaluation of the record, because what you've got in your order is the AG's advocacy in the case.
Counsel,
If I can reserve
you're down to
5.
250 if you'd like to reserve. Thank you.
I'd like to reserve. Thank you.
Your Honors, Orem L.H. Skinner for the Attorney General's Office. I'm here with Elise Meislich and Evan Daniels, also with the office. Judge Catani, and may it please the Court, we believe this appeal is straightforward and can be resolved by a narrow decision. It does not go to the merits of any claim or resolve any ultimate issue of liability under the Consumer Fraud Act. Instead, it asks whether the Superior Court erred in ordering compliance with a pre-suit civil investigatory demand and imposing fees and costs. The Superior Court held a hearing over the course of several hours at which the issues now before the Court were fully addressed. The key question now is whether, in the words of Herndon, the office made some showing at the enforcement hearing that there was reasonable cause to believe that there has been a violation of the Consumer Fraud Act.
Do you agree with counsel that this U.S. versus Powell lays out a 5-part standard that applies to evaluating the motivation and burden that your office has in instituting this sort of demand?
Well, Your Honor, we first note that United States versus Powell is not cited in the briefing, so to the extent that you would like extensive discussion of it, we're happy to submit a supplemental brief. At this point, all I would say is that Powell establishes background principles of what reasonable cause might be in certain kinds of cases. We don't believe that there's anything in Powell that is to the contrary to what is in Herndon. We believe that Herndon teaches the exact standard that applies, which is that there must be reasonable cause. And going to the point of a complaint, for example, the statute used to require a complaint, and now it merely requires reasonable cause. We believe that that is an actually more protective standard. You need to meet reasonable cause, and that could require, in different cases, fact-specific determinations, but it could require many complaints or no complaints. We believe that looking only to a complaint misses, as Judge Portley noted, there's a broad spectrum of information that is available. The appellant's position would, in fact, make it impossible for this office, if we were in communication with some federal government agency like the Consumer Financial Protection Bureau, and they told us of a as yet undisclosed fraud that is being perpetrated on Arizona consumers, we would be forced to not issue a CID until that fraud was actually revealed to the public, and then people could make a complaint. We don't believe that position stands, and we don't believe that it matches with Herndon. So we believe that the key question is merely whether at the hearing before the Superior Court, the office made some showing that there was reasonable cause, and we believe that that standard was more than met. Now, appellant presents in the briefing in here today a long list of defenses and explanations and accusations relating to an ultimate consumer fraud action and ultimate consumer fraud liability, when in fact no action has been or, for that matter, may ever be brought. This is the earliest stages of an investigation in which we are trying to determine whether that should be done.
What's his remedy? What's his client's remedy if the request for information is overbroad?
Right. So the first remedy is to engage in actual meaningful colloquy with the state. My time at the state, limited as it may be, the state's not intending to overburden anyone with the CID. We're seeking to get the information that we need. The record, for example, in this case, from the transcripts of the trial court, show that many of the items that are now being cited as overbroad could have been pulled together in 20 minutes or less. There are records that are regularly kept and can be produced. Now, should a particular target of a CID have certain information that is particularly onerous to get, that's a topic that may be brought up with the Attorney General's office. Reasonable conversations can occur, and in the instance in which that doesn't occur, other documents can be produced, and then the Attorney General's office is in the position of seeking to enforce a CID, with the Attorney General's position being, yes, we got almost everything, but they didn't give us this one item. And then the hearing becomes not, as it was here, about whether a CID may issue at all, but about whether a particular item is, in fact, unduly burdensome and somehow violative of some protection that is afforded to an investigatory target.
Well, was the hearing in this case, did it address both, whether they could do it at all, and then whether it was overbroad?
The hearing addressed both, but the primary focus of the hearing was whether reasonable cause existed at all, with the breadth questions taking somewhat of a back seat, and I would contend most of the record, especially at the hearing, demonstrating that there was no overbreadth at all.
Well, weren't there a couple of employees that testified as to the onerous, the length of time that it would take to try to compile all those records?
Sure, of course, Judge Portley. So when presented with broad questions by appellant's counsel of how long would it take to pull together every single document in here, if you read the transcripts, you get responses along the lines of, well, that's a lot of material. I have no idea. Well, I guess it could take years. And then in response to specific questions, how long would it take to pull together all the leases? How long would it take to pull together lists of tenants? How long would it take to pull together other information? They said, oh, that would be something we would run off of a rent roll report. That would take 20 minutes. That might take a minute, 5 minutes. We're getting answers that are in the range of minutes. And this, I think, goes to the issue of to the extent that there was a contention that any one item would actually be overbroad, that wasn't really made. It was an aggregate statement about the entire CID followed by individual statements, which I think actually contravene the idea that this is overbroad. One thing that we think is very important to remember at this stage is that an enforcement hearing regarding the CID, as Herndon explained well, it takes place prior to the filing of a complaint at a stage when we're merely attempting to determine whether a complaint should be filed. This is a very early stage. as Herndon also explained, the enforcement hearing is merely an incidental judicial adjunct to what is still the administrative investigatory stage of the proceedings. I really do believe that most of the arguments and contentions brought forward by appellant, if pertinent at all, relate to proceedings that would occur later, not proceedings that are occurring now before this court.
Is it possible that there may not, if you were to get all these things and look at it and talk to the good people at 6635 North 19th Avenue, that maybe there won't be a consumer fraud action?
We could not agree more, Judge Portley. The main point of this is that we should not be forced to bring a complaint in an effort to determine the basis, and there's discretion here, and the key is to do informal investigation, open a matter, send a CID to determine whether a complaint is warranted. And the assumption here is that we have sued without suing. And I think that puts many of the arguments in perspective and also explains why many of them are just not properly addressed at this moment in time on the record and with the rules that currently apply. And I think Herndon was very clear that this is truly a special type of proceeding that is focused almost entirely on the evidence presented by the state in support of its own position. The key is whether the state has, by bringing forth materials, reached above the some showing of a reasonable cause. And their appellant, obviously, in the underlying proceedings is welcome to make arguments and positions, but at the end of the day, this is much like an order to show cause. And we believe that we have done that. Herndon, I think, is quite instructive. Herndon says, the question at the hearing is not whether the state's information is true or uncontradicted, but whether, assuming its accuracy, I think this is very important, the state has in its possession sufficient information to satisfy a judge that it is reasonable to believe that there has been a violation of the act. I think that is the true controlling principle behind this type of proceeding, and the key is just did we make some showing of reasonable cause. And we believe that the state met its burden and that the determination in the Superior Court should be affirmed by this court. We just believe that this is a logical application of Herndon that doesn't make new law or really go any further than applying a case that was well explicated at the time it was issued.
Well, and other than Herndon, are there any other guiding Arizona cases that address these pre-suit discovery?
Sure. We think Herndon is the most instructive because it goes into the longest explication of exactly what this type of proceeding should be and what it should not be and what should occur and what should not occur. For example, Herndon was very focused on should discovery be allowed, and in beginning the analysis of what is this proceeding determines that the federal rules of civil procedure, the Arizona rules of civil procedure do not apply, that this is not a true adversary proceeding, and then determines discovery is not warranted. Other cases have been instructive. So the Western Union case, I think, goes to overbreadth. It speaks about the idea that there was a reasonable cause, the CID issued, and then discusses how a request for all money orders for all period of time to Sonora, Mexico, that is overbroad. Here we have nothing like that. We have a less than 3 year window of time relating to a specific property, relating to potential witnesses, ownership, things that are entirely pertinent to the reasonable cause to believe. And so I think I think Western Union is instructive in that regard, but I do believe that Herndon is the most on point because most of the contentions in the appellant's brief, I believe, fail upon a recognition that Herndon, that this is not the proceeding that they believe this proceeding to be. So here we believe that the standard is met. Going back to Judge Portley's question, Green Acres, for example, tells us that we don't need a particular cluster of complainants, a necessary body of people who are complaining in order for an action to be brought, much less a civil investigative demand to be issued. When we go to objective evidence as a point that is brought up repeatedly by the appellant, we believe that objective evidence is not merely a complaint. We believe that objective evidence is other information that is available, and that includes news reports, and that includes other court cases, testimony in those court cases, and investigators' observations. All of that is objective evidence. And I would also contend that in many cases may be substantially more useful objective evidence than a certain number of consumer complaints. And as to one note here, the findings were made independently. You can, going beyond the...
How do we know that?
So the number one piece of evidence I would say is, first, they were issued with the judge's signature. The judge.
Well, you submitted them, the judge signed the form you submitted. How are we to understand that she either agreed or didn't agree or interlineated some things that would show that, well, you kind of agree there, but, having a nuanced review of the evidence?
Sure. Well, starting with the basic idea that I think in the absence of contrary evidence, we presume that Superior Court judges mean what they say when they enter things on their dockets. And then second, I think it's very simple as it may seem. On the second page of her order, she marked out information and hand-entered different information, showing that she reviewed, made a determination, agreed with most, not all, and then entered an order. So I think that those pieces combined, you need the mark out and additional edits, but I think to the extent there's any question that establishes that the Superior Court judge knew what she was doing and did it for her own purposes and reasons. And
Which ones did she mark out?
sure, one second, Your Honor.
The findings of fact.
There's a page at the back, Your Honor, where she instructs when, it's on page 6.
On page 6.
It
You got
says
30 days instead of 14 days.
Right. Small as that may seem, I think, Your Honor.
Oh, yeah, I understand that. I was just,
Yeah.
it seemed to, your statement seemed to say it was in the findings of fact, and so that's why I was,
You're right, Judge. Certainly misspoke. It's on page 6.
okay.
At this point, Your Honor, we really believe that Herndon teaches the outcome here, fully explained how this proceeding should have gone. This is not a proceeding that we think, as Herndon even said, it's not a particularly complicated, although it is important, determination. I believe the state has met its burden, and that the issues raised are almost entirely issues that need not be raised now and are, in a sense, unripe, but also just inapposite. With that, unless the court has other questions.
Thank you.
Thank you.
Mr. McGill.
Your Honor, let me start by saying, with all due respect to the AG counsel, he might stand up here today and say that it would take 20 minutes to produce that production, but I was involved in that production, and it took a couple of weeks to get that production. That's how much was asked. We had to download. There were 310 units, and when you look at the subpoena in the case, they asked for all the ownership documents of 6635.
I just wanted to know what was in the record, because that's
I understand,
what governs
but-
us,
but
not what
Right.
actually happened.
Right,
what's in the
and
record.
what's in the record, just so you have an appreciation of this, it would take, and we had testimony at the hearing as to what it would take, and we had testimony that was unrefuted by the AG's office. They put nobody up there to say what counsel just conveniently said, that it took 20 minutes. When we were at the evidentiary hearing, there was no AG evidence to dispute the fact that I put on 2 witnesses, and they said it would take at least a couple of weeks to go through this stuff. And I was involved in the production, and it took at least a couple of weeks because they asked for all the repair bills. There were thousands of documents that we produced to the AG. That's how broad the subpoena was. And they argued to Judge Bustamante.
How it would have been okay if it would only take 2 days, 3 days. What's the outer limit, the bound for the position you're taking?
According to the AG office, there is no limit. If you look at the CID in this case, there is no limit to the breadth and the scope of this CID. They had no limit. It was not targeted. It was not targeted to fraud. It was not targeted to a legitimate concern about a consumer fraud complaint. And I'm not arguing. I know, I said at the outset, counsel misstated my position. I didn't argue that they don't have a pre-suit investigative authority, but they have to exercise it in good faith, particularly when they're the government going in with a clearly overbroad subpoena to ask for all the papers and effects and tax returns of a private party in this country. This is the kind of abuse that goes on sometimes by the government, and the only check and balance that the private citizen or private corporations have is this court. That's it. Because you have an AG attorney that gets up here and tells you that thousands of documents would only take 20 minutes. That's what was just told to you. And it's not true. Number two, when you go to Herndon, counsel said, well, if you could allow him leave for a supplemental brief on the U.S. versus Powell case. The U.S. versus Powell case is cited in Herndon. It was in his answering brief. It was in their briefs to Judge Bustamante. The Herndon case is what he just argued for 20 minutes. And the U.S. versus Powell case is in the Herndon case. It's cited in the Herndon case. So counsel
And we know
should
that,
know.
and we know that Powell has been modified as a result of subsequent congressional action.
Well, except that Powell, it was not modified that.
Oh,
that,
not at the time, but
Right.
Congress acted with respect to when the IRS could do certain things.
Right, and one of the five factors was that they're not entitled to go on a fishing expedition, overbroad search, in the absence of any legitimate fraud or deception claims, because we don't have that here. We just have an AC problem, breach of contract. And you didn't hear him tell you that there was fraud. You didn't hear him tell you that. And they have not sued for fraud in the last 2 years, which tells you something, too.
Maybe they won't after they get the information, but at least they're trying to determine.
Right, and maybe they won't, and I hope they don't, but here's the harm, Your Honor. Here's the harm in this. When the government goes in with an overbroad search, which is what our founding fathers had a problem with, which resulted in the U.S. Constitution against England, when they go in with an overbroad search to search for private effects of U.S. citizens, there's a danger in that because we don't know what their motives are. Here's one motive. They had 2 prior cases, hundreds of thousands of dollars in civil fines, and they were able to get all the information, all the proprietary information of my client on an overbroad subpoena without a scintilla of evidence of consumer fraud, and they got it, we think, for collection purposes. They know the assets of my company for collection purposes, and that's the danger. That's the mischief in this kind of thing. And there could be plenty of mischief that I'm not talking about this morning. The point is, private property rights, the government does not get the presumption
We'll give you
over
30
private property
30
rights.
seconds.
Okay, 30 seconds. The last thing here, Your Honor, that should tell you something is they never got an administrative warrant before they issued the CID when Melissa Ott went onto the property and purportedly investigated these units. You have to get an administrative warrant. I filed a motion to suppress, and Judge Bustamante, she reviewed and ruled on that motion to suppress after she ruled that the CID was affirmed and would be upheld. And to rule on a motion to suppress on behalf of a private property owner, a motion to suppress an illegal government search, again under the Constitution, and rule on that after you've already okayed the offending action by the government, that's anomalous, it's backwards, and we're injured by that. Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. We'll take a brief recess. Thank you.